Very happy Friday to everyone. Summer is here, if you didn't notice, and so is our second quarter advisors forum, part of the Elville webinar series. My name is Jeff Stauffer, Community Relations Director with Elville & Associates, and I'll be your moderator today. Today's topic is the Corporate Transparency Act, what advisors need to know, and your presenter is the one and only Stephen Elville, Managing Principal and Lead Attorney here at Elville & Associates. And you received the presentation slides by email from me this morning to take notes if you wish. The slides are also available in the section marked handouts on your screen to download at this time. And for our professionals on today's webinar, welcome for CFPs, CPAs, and most everyone else in attendance. As is the case with all of our webinars, continuing education hours are available for attending today. And if I don't have it already, please email me your ID number and accreditation so I can submit your CE hours for approval and send out certificates as well. For any questions for today's presentation, please forward those to Steve and me, and we'll be happy to provide feedback after the presentation. And everyone will also receive a post-webinar feedback email right after the presentation, so please just take a few minutes to fill out this very brief survey and offer us your thoughts about today's presentation. We have a lot going on here at Elville & Associates, as always, and we're very blessed to be busy and working with clients. More than we can ever begin to talk about right now, but just a couple highlights. We just opened our new Montgomery County office at 1700 Rockville Pike, Suite 530 in Rockville. And we like to hold an in-person advisors forum in the fall, so stay tuned for that. Stop in at any time and say hello to us. Our principal attorney, Lily Hummel, is there all the time at that office, so look forward to seeing you there. Our biggest event of the year, our annual client and community education event, is set for November 9th, Saturday, at the newly renovated 10 Oaks Ballroom. So once again, we'll be there. It's going to be a capacity crowd of probably 300 people, so be sure to stay tuned for details, which are coming out in the next week, and RSVP early. So as for you, our advisors here on today's forum, you're very important to us here at the firm. And we always strive to work in a collaborative planning team approach for clients' best interests and yours. And while maintaining the highest level of trust and confidence, we want to help you protect, keep, and grow assets under management for your practice. We also welcome the opportunity to connect with you to discuss the best ways to accomplish those goals and ideals. So I'd like to share just a bit about the firm and Steve, and then we will jump right into the presentation. So you should be able to see my screen here. Elville & Associates, founded in 2010 in Columbia by Stephen Elville, and we offer several different practice areas for our clients here at the firm, including estate and special needs planning, elder law and elder care planning, estate and trust administration, business law and succession planning, guardianship and litigation, tax planning and asset protection. We have 9 attorneys, 12 staff members, in 5 locations. We're coming to you live from the Columbia Gateway community today. Fortunately, the air conditioning is working. Our mission, as it always has been and always will be, is to provide practical solutions to our clients' needs through counseling, education, and superior legal technical knowledge. And we do focus on education a lot here at Elville & Associates in several ways. First, through our planning processes with our clients. And we have different programs to suit all families and individuals here at the firm. Also by way of our educational webinars and workshops in the communities that we serve each year. And also by way of our accredited client care program. We're one of only a couple firms in Maryland to have a client care program accredited by the Client Care Academy in Boston. We have our social event coming up in September, going back to the Orioles game on September 6th. That was a great game yesterday. 17-5. It's more like an NFL score, I think. Ravens over the Jets. We also just had our second quarter client care program event at Anne Arundel Community College. We had an antiques road show where we had an antiques appraiser appraise some of our clients' valuable items, which was a lot of fun. So always something new with the client care program, but it's also a program whose primary focus is on ensuring that our clients maintain and update their planning on a yearly basis. And it's also the highest and best form of partnership with our firm. We also work with the ideals of client education, collaboration, and compassion in mind with every client every day here at Elville & Associates. And just a bit about Steve. His work as an attorney for 23 years plus has been centered in elder law, special needs planning, and estate planning with an emphasis in the areas of tax planning and asset protection. A member of many different national membership and professional organizations, including just a few, such as the National Academy of Elder Law Attorneys, the Academy of Special Needs Planners, and the National Network of Estate Planning Attorneys. Steve works to offer peace of mind to clients by creating solutions to their needs through counseling, client education, and the use of leading edge legal technical knowledge. Steve is a very seasoned speaker and presenter. If you haven't heard him talk before, each year offering many webinars, workshops for businesses and their employees, conferences, and continuing education events each year. Steve was also named to the Maryland Super Lawyers list for a 9th time and 8th consecutive year in 2024. So congratulations there, Steve. He also had a feature story written about him in the National Super Lawyers magazine about the Elville Center for the Creative Arts, which is our firm's charitable organization he founded in 2014. I'm very fortunate to be the executive director of. If you'd like to learn a little bit more about the Elville Center and what we do to make a musical difference in the lives of children, please reach out to me directly, and I'd be very happy to share our story with you. Today, though, we're going to learn a little bit about the new law that's going into effect, the Corporate Transparency Act, which affects millions of businesses on a yearly basis going forward. And Steve's going to share some information about that with you today. So Steve, welcome. I'm going to make you the panelist here and presenter.
Jeff, thank you so much for that introduction and for all you do. And I'm just going to get myself situated here and get my slideshow started. So I want to say hi and thank you to all of our attendees today, our special guests. It's a beautiful day outside from where I'm sitting here in my conference room number 1 at Elville & Associates in Columbia, Maryland. Wherever you are, welcome. And thank you for spending your valuable time being with us. And I hope you're going to do something fun for yourself today and this weekend. It's my favorite time of year, June. So I hope you make the most of it, even though it's gotten pretty hot recently, but maybe you'll be able to find something that you can enjoy. And in the time that we have together today, I want to be efficient. I want to be of real value to you. And we're going to take a little bit of a slog here today through this. And I would say that go as far as to say after this presentation, I hope that we can get to know each other better if we haven't met before. We want to be a resource for this kind of material. And it's not easy to convey this particular material because it's tough stuff. And so I'm just going to remind Jeff as a little bit of an attempt at humor here. Jeff, you see that I'm not wearing a tie today, which I normally do. And you might wonder why that is.
Steve, why is that?
Well, I was just thinking to myself this morning, talking about the Corporate Transparency Act is a little bit like having to go to the dentist, right? So I wouldn't wear a suit to the dentist, right? Or suit and tie. And of course, trying to be humorous here this morning. This is really tough. We're going to be going through some motions here to really methodically go through the material. And it's an unpleasant experience, in my opinion. And what is the government trying to do here? Well, clearly they're trying to combat terrorism and money laundering. And the government is looking at business entities, not the big ones, but they're looking at the moderate sized ones and the smaller ones, because apparently that is where the fraud and money laundering and terrorism activity is going on. So we have to believe that with this particular law coming out, which many of you have heard about and maybe even seen other presentations, we have to assume that this is a very, very serious business. And we're going to have to go through it methodically. So I apologize in advance. Hopefully you won't need any anesthetic. Hopefully you will grab a second or third cup of coffee here this morning and stand there or bear with me as we go through this material. And I am going to be very, very step by step with this. I'm going to really hold myself back and hold you back a little bit to really make sure that we go through each slide almost in a unbearable narrative fashion, because I've looked at this material. I actually gave this presentation a few days ago, and it's pretty clear to me that unless we do that, we're really not going to follow or appreciate the nature of this material. And that's what I really want to convey to you today. I also want to thank my good friend, Corey Howells, who is a wonderful estate planner in Raleigh, North Carolina, for sharing this particular presentation with me that he worked up for the North Carolina Bar. And I really appreciate Corey's methodical approach to this presentation because there's a lot of material out here. There's a lot of gurus that are out putting out this material about the Corporate Transparency Act. But Corey really drilled down, and he was kind enough to share this information with me, which I am very privileged to share with you. So hopefully we won't need any laughing gas or anesthetic, but maybe we will laugh a little bit as we go through this. But otherwise, it's very, very serious business. And lastly, as we get into this material, I promise that as you get into this with me this morning, you may say to yourself, what am I doing here? Why am I putting myself through this pain? Well, I promise there is going to be a reason. There's going to be a climax or a denouement, as we might say, to this material where it's going to be worth it. Having sat through this, if you're not already aware of what this is all about, your willingness to sit through this methodical presentation, I promise, is going to be worth it because you're going to see what the risks are to our clients and to any of you on this presentation this morning who have a business entity. So with that said, thank you for sitting through our rather long introduction, and we're going to get started. Obviously, this is not legal advice. We're meeting in a very casual setting. We're not in an attorney-client relationship, but of course, we want to be a resource to you and your clients on a personal basis. So what are we going to cover this morning? And again, I thank you for your time and sticking in here with me. We're going to talk about the background of the Corporate Transparency Act. We're going to talk about what reporting companies are, company applicants and what they are, who they are, and who the beneficial owners are. Okay, we're going to really just take our time. We're going to talk about who must file the Beneficial Ownership Information Report. The Beneficial Ownership Information Report. We're going to talk about what must be reported to FinCEN, the Financial Crimes Enforcement Network, FinCEN. What are the exemptions to the CTA, the Corporate Transparency Act? So there's many exemptions, and this is good news. But as we get into the minutia, you'll see that there's also a lot of ambiguity. And one of our real challenges going forward, as you will see, is how are we going to handle this for clients, and how are we going to make sure directly or indirectly that clients are taken care of. What are the steps that one must follow to comply? And very importantly, what are the filing deadlines, pitfalls, compliance, and penalties? Okay, so along the lines of all of that introduction, we're going to just methodically go through the material. What is the CTA, the Corporate Transparency Act? Well, it was enacted by Congress January 1st, 2021 as part of the National Defense Authorization Act for 21. And its primary objective is to assist the Financial Crimes Enforcement Network, FinCEN, in its efforts to prevent various financial crimes, including what I mentioned earlier, money laundering, terrorist financing, corruption, and tax fraud. Now, I will just say as an aside, my impression, having gone to the Heckerling Institute in Orlando for estate planning over these many years, I've seen this kind of thing coming. And it may or may not be directly related to some of the European efforts to clamp down, and the European Union and other European countries to clamp down much more so and much more quickly than we have in this country on targeting terrorist activities and corruption and money laundering. So to me, this is no surprise, and we're going to have to live with it going forward. And lastly, on this slide, the final rules implementing the CTA were issued by the Treasury Department September 30th, 2022, with an effective date of January 1st, 2024. So these dates are critical, right? Especially that last one, because we already are under the auspices of the Corporate Transparency Act right now. Under that law, it's already in effect, although its more onerous effects are going to be, as you see, in 2025 coming up. Now, if you're with me so far, who must file this beneficial ownership information report? That's a mouthful. Well, reporting companies. So let's define what this is, okay? A reporting company or companies are all businesses, all business entities operating in the US. Well, that's quite a lot, isn't it? Corporations, LLCs, entities created through filings with the Secretary of State, or obviously here in Maryland, the State Department of Assessments and Taxation, as well as the Secretary of State. So that's quite broad, okay? That's important. Exemptions. Certain entities are exempt, and we're going to look at an entire list of exempt entities. Mostly those subject to existing disclosure or regulatory schemes. So, for example, large corporations are exempt, for example. General partnerships, sole proprietorships, and most trusts are not considered reporting companies. And then reporting requirements. Reporting may nevertheless be required if such an entity is a beneficial owner of a reporting company. Okay, so I encourage you to take this PowerPoint. I encourage you to get a printed copy of it, put it on your desk, take it into client meetings where you know you have owners of businesses or families that have LLCs for real estate. We're going to just be redundant throughout this to drive home these points. This is something we have to now take seriously. We are 6 months into 2024. We still have time. You still have time to continue to learn about this, to continue to get your mind around it, and to disseminate this information to your clients and their friends and family. So let's take a look at this chart, and I thank Jeff for creating this. I want you to, let's say, focus just for today's presentation on the left side of the screen. And going from top to bottom, I think you'll find this simple chart very useful as you talk to your clients. So we have, companies that are created under US law, companies that are created under foreign law. Let's focus on the US law side for simplicity today. So as we go down, very simple flow chart, is this company a corporation? Well, if yes, it may be a domestic reporting company, right? So this is going to be a flow chart here that we have to take seriously. If it's no, we're going to go down. Is this an LLC and not a corporation? If yes, it may be a reporting company. No. Now we say, was the company created by the filing of a document with the Secretary of State or similar office or under the law of a state or Indian tribe? So yes, if that were the case, it's still going to be possibly a reporting company. So we're going to have to screen these issues to determine whether our clients or friends or family of clients have to report or whether they are, to the right, not a reporting company. So use this flow chart, and thank you again, Jeff. Now, this is just the beginning of the nightmare, we should say. Obviously, we have to look at it positively. We have to look at this as, I hope, this is a necessary protection for our society, or government wouldn't be putting this out there in such a way, and with onerous penalties, as we're going to see coming up, for non-compliance. So what are the exemptions from the CTA? Well, let's go through this methodically again. Securities reporting issuers, governmental authorities, banks. See, large institutions like this are exempt. Credit unions are exempt because they are regulated on an otherwise basis. Depository institutions holding a company or holding company. Money services businesses, broker or dealers in securities are exempt. And I know many of you on this webinar this morning are affiliated with such an organization. Securities exchanges or clearing agencies. Other Exchange Act registered entities. Investment companies or investment advisors. Okay, and I know we have many on this webinar today. Venture capital fund advisors, insurance companies, state licensed insurance producers, Commodity Exchange Act registered entities, accounting firms are exempt, public utilities are exempt, financial market utilities are exempt, pooled investment vehicles are exempt, tax exempt entities are exempt. Now this is one of the biggest issues. So that's one of the easy things here. Our charities or tax exempt entities are exempt. And that's one of the first things that you're going to encounter is that your contacts, your clients, your sphere of influence, folks that are involved with charitable organizations are going to get very nervous about this, but just assure them that these tax exempt entities are exempt. Entities assisting tax exempt entities are exempt. And there are supporting organizations and other entities that do support tax exempt entities. Large operating companies, subsidiaries of certain exempt entities, and inactive entities. Now, all of these 23 listed types of entities are exempt. What's one of the first things that comes to your mind as you start to let this sink in? Well, one of the first things that probably will eventually come to your mind is that, wow, well, inactive entities are exempt, and we'll have to look at the further definition of what an inactive entity is. But for also entities that are maybe not needed any longer. So let's say that we have clients that have entities that they formed these entities. Maybe the entities are relatively inactive, or they don't make much money, or they don't really serve a purpose anymore. Well, one of the things we're probably going to want to do is encourage clients to get rid of these entities rather than have to worry about the onerous penalties that we're going to get to. So let's take to heart these many exemptions and start looking at ways that we can not only screen who is required to report, but very quickly screen who is exempt. And hopefully over time, this will become clearer and clearer. Now, what must be reported to FinCEN? Well, we're doing pretty well on time, and as we get through this presentation, we may end early, but we'll just keep being methodical and probably go up to an hour of total time. What must be reported? And this is one of the things we want to get under our belts. Well, company information, legal and trade names, current U.S. address. So far, so good. Jurisdiction or formation or registration information. IRS tax ID number. So far, so good. Let's go down now to company applicants and beneficial owners. Full names, dates of birth, residential address. Now let's stop here for just a second. Remember that registered agents and others many times are just put in for convenience. Maybe it's a relative, maybe it's someone who was just willing to serve. But now, people that are involved with these entities have to provide all of this information, including their home address. Look at this, a unique identifying number with a valid U.S. passport, driver's license, or ID card, okay? Maybe some of the folks that are involved in the entities are not happy about this. They never had to report this. They have to provide now a copy, let's say, of their driver's license. Well, this is not going to make these individuals very happy. On the other hand, maybe it's not going to be a big deal for many people, but it's still now a new day, and our clients are going to want to evaluate and reevaluate, do we really need these entities? And if yes, okay, now we have a new burden, All right, let's go to the next slide. Who are company applicants and beneficial owners? Who are company applicants and beneficial owners? Well, company applicants are individuals who filed the company's formation document or were primarily responsible for directing or controlling the filing. Now, if I just look at that definition and I think back to some of the entities I have as a person individually, and I think about the persons who filed those things for me, if I take this literally, I've got to know who that person is, and I kind of have to, still be able to reasonably be in touch with them, it looks like. So I have to be able to identify these people. Beneficial owners are individuals who directly or indirectly, perhaps this is one of the most important definitions for today, persons who directly or indirectly exercise substantial control over the reporting company or own 25% or more of the ownership interest of the reporting company. This group generally includes senior officers, LLC managers, managing members, owners of 25% or more of the company, and possibly others. So now I think we're finally starting to see some of the ambiguity as we go through step by step. Now, if you're still with me, what is considered substantial control? Well, substantial control includes the authority to appoint or remove certain individuals and the ability to direct, determine, or have a substantial influence over decisions of the reporting company. Now look at this next sentence. Analyzing who may have substantial control over a company may be the most complex issue in determining who is considered a beneficial owner. Okay, so let's just stop right there for a second. Some of this is going to be very straightforward. Some of these questions are going to be easily answered. And for other entities that you're dealing with, this is not going to be easy to answer at all. So we want to first take care of clients and make sure that they are directed properly. We're going to talk about who's going to help the client do this. Is the client going to do it themselves? Is the client going to use their CPA? We know many CPA firms are vying for this business. What about the collaborative advisory team being on the same page about who's going to report and who's going to really be the point person? And as we're going to see in the other aspects of the presentation before we're done, particular company, for example, needs to identify a person within the firm who is the point person for this. So as you start to get into this ambiguous part of the presentation now about going back to the prior slide for just a moment, company applicants, who are beneficial owners, and who are the individuals who have substantial control over a particular company, we start to see how the complexity of the CTA could start to play out. Now, before we continue, I just want to say that in the world of estate planning, estate planners are always looking for the next important thing to let clients know about, as you are in your field. We want to make sure that we're advising clients early and often. And we also tend to, I think, as a group, create a sense of urgency about things that sometimes are speculative and things that are maybe not so speculative. And I think the important thing about this presentation is that all of the hype that you may have heard, and all the hype I have heard, and folks here at Elville and Associates have heard from our colleagues across the country, this is probably good hype, because this is not speculative. This is not a speculative thing about tax law changes. This is something that we know is written in stone right now in the law. So with that said, we have a serious approach to something that we know is not speculative. And here are the deadlines and potential pitfalls. Companies formed prior to January 1st, 2024, okay? We still have roughly 6 months, 6.5 months to report by December 31st of this year. So companies that were formed in 2023 or before Those initial reports are due by the end of this year. So many of you have perhaps 10, 20, 30, 50, over 100 clients that have entities. You need to make sure they are informed. And I'm sure many of you have already done that. Companies formed between the first of this year, 2024, and the end of this year. Initial reports are due within 90 days of formation. I'm going to say that again. For companies that are formed this year, 2024, or in the process of being formed right now, as I can think of several right here off the top of my head. Initial reports are due within 90 days of the formation. So you, as now someone who's looking at this material halfway through the year, almost halfway through the year, we now need to look at this and say, are there people that we know that have formed entities that have reporting requirements now within 90 days of the formation date? And do we know anyone that's past that? Because the onerous penalties could affect them. Now, here's what we need to know going forward. Companies formed January 1st, 2025 or later going forward, reports are due when? 30 days after formation. So this right here should be up on your wall or on your cork board if you still have the old cork board in your office. This should be somewhere stored or presented where you can, displayed where you can see it. Okay, let's continue now with filing deadlines and potential pitfalls, and I promise the pain of this presentation will be worth it because we're getting to what clients really need to know other than the mechanics of the CTA. So while initial reports are getting all the attention right now, the requirement to file updated reports will be the real administrative burden. Yes, the updated reports that I just said are going to be the real burden over a company's lifetime. And these are the things, according to the research, is going to be far more likely to result in penalties. Okay, so look at this underlined sentence. Updated reports must be filed when? Within 30 days of any change to the information on the beneficial ownership information report. 30 days. So going forward after 2025, the updated report is due within 30 days if the beneficial owner moves to a new residence. Are most of our clients going to remember this? We know the answer. The client gets married. The beneficial owner gets married and changes their name. Obtains a new driver's license or passport with different identifying numbers or addresses, or upon the death of a beneficial owner. Wow, if we just look at those four things, how much exposure does a client have, a beneficial owner have, or the beneficial owner's personal representative if they pass away? How big is that? Okay, that's big. This will require reporting companies to be vigilant in monitoring changes in the beneficial owner information report for all owners. It also adds additional burdens with tight deadlines, I should say, when administering estates, as I just mentioned, estates or trusts after the death of someone or upon incapacity. Wow. So I don't think that it's a stretch to say that not only do we need to display this information in our offices or have trainings on it for our employees as we take care of clients, but this is going to be a pervasive part of our lives going forward. This, especially, I can just speak for us here at Elville and Associates, this is going to pervade all of our communications with clients, all of our disclosures, all of our, our engagement letters, which we've already changed. So I encourage you to think about this from your perspective while you still have time. You still have time to get ahead of this. You still have time to look back in the last 6 months and say, Have any of our clients formed an entity? Well, we know they have 90 days. Are any of our clients forming entities now? Are any of our clients, have they changed their addresses? Have they gotten married? Do they have LLCs? It's a morass, and it's here to stay, I believe. So here we are. I would create systems and processes, and maybe one thing that would be necessary here is to help our clients create systems and processes and to work with our collaborative team. Perhaps the CPAs on the team are going to take this and run with it. Perhaps they're not. Perhaps you will identify soft spots where this is not being done. So enough said there. We all are on notice now. The CTA is something we have to take very seriously. Now, I promised there was a climax or a denouement, but it's not always pleasant. So I didn't promise it was pleasant, but I promised there was a climax. So let's look at this now. Penalties and compliance. Failure to timely report and update. I think that's what I'm going to put on my computer screen. And update. Complete and accurate information, right? If you don't report it, you don't update it, it can lead to civil or criminal penalties, including civil penalties of up to $500 per day, $500 per day, unlimited, by the way, $500 a day, unlimited, and criminal penalties or imprisonment up to 2 years or fines of up to $10,000. All reporting company information and beneficial owner information reports must be filed electronically through FinCEN's secure filing system, or through an approved third-party integration. A reporting company's failure to properly comply with the CTA can have significant, obviously, legal and financial implications. So timely and accurate compliance is essential. So because we have very busy days, very busy lives, very busy calendars, very busy and huge demands on us, all of us on this webinar. Perhaps we should take a minute or two and really take the time now, while you've set aside this time, and just make a few notes to yourself. I'm going to do the same thing. We're all learning. We're all taking this under advisement. What can you do right now, today, to start really getting yourself ready for this? Let's take 2 or 3 minutes on this. I'm going to set my timer here on my cell phone, and let's take 2 or 3 minutes. Just make some notes to yourself. What will you do or can you do so you don't put this off anymore? We don't want to put this off anymore. I would, if I were you, make a silent vow that by mid-July, or hopefully by the end of this month, you will have a policy and procedure in place, not only for your own company, for your own clients, but also, not only how you're going to approach it, but how will your clients approach this. Take this presentation, disseminate it to all of your sphere of influence or employees, and let's take 2 or 3 minutes, and I'll stop talking just for now. We'll take 1 more minute. 30 more seconds. I don't know about you, but I've gotten a couple of really good ideas here, just brainstorming. Fifteen more seconds. Okay, thank you for taking that time. I hope it helps some of you to focus for a few seconds. And it's amazing what you can do when you brainstorm like that. And hopefully you wrote down several things. I wrote down several things, but got at least 2 epiphanies about things I would not have thought of. So hopefully you've thought about how you're going to disseminate this information, manage it, help clients with it, and you can do that further in your own time. For now, let's continue through the presentation. We're almost done. So small business compliance, know your company's structure, know your client's company's structure. Is it an LLC? Is it a corporation, partnership, trust, sole proprietorship? How many of you have asked your client for their corporate documents and had to wait quite some time? Maybe wondering what they ever were going to send them. Well, if you've experienced that, you're not alone. How many of you have requested this information from the client's CPA and had the same dilemma? Well, hopefully not, but sometimes the information is not forthcoming. So this now puts us on a new track. We cannot wait for that information. We have to know what it is, and we have to protect clients, right? Now, there are some law firms and maybe even CPA firms and others that I can't speak for that are going to opt out. They are going to opt out of actually advising clients about this. I don't know how any law firm could reasonably do that, but I think that probably there are some that are going to opt out because of the liabilities and liability issues and so forth. But I think because clients need protection, I think we have an obligation to help them. Let's go to the middle of this slide. LLCs and corporations. Unless an exemption applies, all LLCs and corporations must file. So perhaps one of the things to do here is, when in doubt, go ahead and file. And of course, other entities. All right. So as we go forward, we want to look at our exemption list. You can also review FinCEN's compliance guide. So here we have this link, so to speak, of how to get over there to the FinCEN website and look at this. And that should be one of the things I would print off or download. We want to look at that compliance guide, okay? Common exemptions, the most common exemptions, remember, are banks, accounting firms, tax-exempt entities, large operating companies, certain subsidiaries of exempt entities, and inactive entities. Now, let's talk about what inactive entities are, because that might knock out a lot of what we're worried about for some clients, okay? Companies formed prior to January 1st, 2020, companies that are not engaged in active business, not owned by a foreign person, hasn't changed owners in the last 12 months, hasn't sent or received funds in an amount greater than $1,000 in the last 12 months. You see, they're targeting relatively small businesses here, and owns no assets, right? Now, again, I would say, when in doubt, file, right? But here are some criteria for what is an inactive entity. For company applicants, for newly formed companies, determine who are the company applicants. Who are the company applicants? For all reporting companies, determine who are the beneficial owners. Use these definitions throughout this presentation to break down, to use to create your own flow charts, okay? Trusts or other entities. Now, this is going to be one of the morasses. For reporting companies whose owners or managers include trusts or other business entities, take special care to evaluate who may be considered a beneficial owner. This could be the grantors of the trust, the trustees, the beneficiaries, or the trust protectors. Remember, many trusts these days are being drafted with trust protectors, special fiduciaries. Obtaining necessary information. Contact each company applicant, beneficial owner, and obtain their personal information or documentation for the filing. I can see already or feel through this webinar that many of you have just reached for some kind of Tylenol, Advil, or other pain reliever. So this is where we need the laughing gas, Jeff. I wish I could provide some, but I don't have any, but I will smile about it. This is going to be very difficult for a lot of people. Therefore, I think one of the easiest ways to deal with this is not only making clients aware, but helping them have a system that obviously they have to be responsible for. You can't be responsible. We can't be responsible for everything for these clients, but we can assist. We can assist in a methodical way. Or have the individuals, and this is what I was saying here, have them apply directly to FinCEN and obtain their FinCEN identifier number and provide that number to the company. Okay. File the company information and beneficial owner information report through FinCEN's online filing system. So you're going to have to decide as a practical matter how much you can help your client, how much you can reasonably help your client, and what they're going to do on their own. But I would say defining these responsibilities between the advisor team and the client is really the key. Ensure people are informed. So ensure beneficial owners are informed. All beneficial owners must be made aware of the requirement to notify the company whenever their information report changes, their personal information changes. Secure information. Implement a secure system for storing the personal information of beneficial owners. So now this is another burden, mostly for attorneys or CPAs, I can imagine, but for all the collaborative team to understand this. And have regular follow-up. Implement processes regularly to follow up with beneficial owners to confirm that no filing information has changed. Now, this is kind of the antithesis, right? So I like this last thing here. I like this idea that obviously there's this proactive duty of the beneficial owner to tell us or tell FinCEN that information has changed. But I like this idea that they could affirm or confirm that no information has changed. So I like that approach. And you know, this is going to be something that all you can do is all you can do. But we do have to face this issue because it's not speculative. It is here probably to stay. As I mentioned earlier, consider advising your clients to dissolve any entities that are not needed or inactive. Consider amending governing documents to address beneficial owner issues and their obligations regarding the CTA and the information necessary to complete filings. Can you imagine if owners or beneficial owners don't comply? They just won't comply or they won't produce this information. It could be a nightmare. So possibly amending governing documents is a good idea. Consider business restructuring or other changes to the governing documents to reduce compliance burden. All right, these are kind of self-evident things. So as we begin to wrap up, and we will wrap up on time, be efficient, here are the key questions for beneficial ownership. Do any individuals own 25% or more of the company? Do any two individuals jointly own an undivided 25% or more interest in the company? And again, use your flow chart, use your definitions. Does a trust own 25% or more of the company? A trust. Does another business entity own 25% or more of the company? We know there are many such instances. Does an individual in the aggregate own or control 25% or more of the company individually through one or more trusts or through one or more business entities? Okay. Has the company issued any profit interests? Has the company issued any convertible instruments? If the company was formed on or after January 1st, 2024, who filed the articles with the state to form the company? That's one of the first things we talked about. So we want to harken back to the history of the entity and who were the individuals involved in the creation of that entity. Key questions for substantial control. Now remember, this was one of the biggest ambiguous issues. Does the company have senior officers, presidents, chief financial officer, general counsel, chief executive officer, chief operating officer, or manager of an LLC? Okay, so we have to think about who those are. Are there any other officers who perform functions similar to a president? You see the ambiguity here: chief financial officer, general counsel, all of these executives. Number 3, does the company have a board of directors or similar body? If so, do those individuals have an ability to appoint or remove a majority of the board or similar body? Wow. So we want our business law professionals also to be involved in this process. For example, we want people who are perhaps specialists to be able to advise on these issues. You may have to bring in such individuals. Does any individual have the ability to appoint or remove a senior officer? Are there any individuals who have substantial control over the company in any other manner? Continuing, does any individual direct, determine, or have substantial influence over important company decisions? This includes the nature and scope of the business, sale, leases, mortgages, or transfer of principal assets of the company, reorganization, dissolution, merger, major expenditures or investments, issuing equities, incurring debt, approving budgets, selecting or terminating lines of businesses, business ventures, geographic focus, compensation schemes and incentives for senior officers, engaging or terminating significant contracts, amending substantial governing bodies, documents, policies or procedures. Wow, this particular issue, who has substantial control, is a big one. Well, we got to the climax, and then we went through a bit of minutia after the climax, so thank you for hanging in there with me. It's almost 11 o'clock, and I hope what you've gleaned over the last 55 minutes or so is something that you will take to heart. You may have heard other presentations on the CTA. I have never seen one as comprehensive as this for purposes of shielding oneself from the issues that could be deemed to be something that has liability for you, depending on what your role is, what your field is, whether you're a CPA advisor or lawyer on this webinar, or other professional. But really to help you think through the seriousness of this at the mid-year point, and we still have time. We have time to really get our own entities registered. Many of you have your own entities. Many of our clients have entities, and really helping them work through the simple processes, the more complex processes, determining what's exempt. So as we take next steps, notify your clients, because they may be impacted and will be impacted by the CTA. And if they personally are not impacted, they may very well have children or other relatives or friends who will be impacted. Determine if you, the professional, will help the client with CTA compliance. You've got to be careful about that because there's a lot of potential exposure. And of course, taking care of the client so they don't have exposure. Obtain a FinCEN identifier number. Let's just file if there's any doubt in my mind. Implement systems and annual follow-up processes for clients, but also help them implement their own systems, right? And encourage them to do that, and hopefully other counsel for the client and their entity, their business, will also be on the same page to really help them understand and be proactive. But as we know, for many of you that are on these webinars, in this webinar this morning, not all advisors are proactive. Not all advisors are advocates for clients. So to you on this webinar who will be these advocates for your clients, I salute you. And at the same time, be aware that this is a really hot button issue. This is a trigger issue, and you've got to protect yourself as well while helping the client and helping them have their own system of compliance or relying on professionals to do it. So as we wrap up, I'd like to schedule a meeting with any of you who want to discuss this. I'd love to have breakfast or lunch with you, or even a Zoom call. And if you have any questions about how can we advise clients better together for the CTA or any other issue, I'm happy to talk to you and glad to meet you if we haven't met. And if we haven't seen each other in a long time and we do know each other, I look forward to that as well. Let's talk about how we can collaborate. Let's review existing documents for clients. Let's look at existing plans. Let's form some study groups if you're interested in that. We all are learning all the time. We're all raising our practice levels. We all want to help clients, take care of clients, and for the advisors on the financial advisors on the webinar here, we want to help you keep assets under management and grow assets under management and work with you collaboratively. We want to talk about techniques to accelerate growth for clients and for us, and also have family meetings I'm going to encourage you to do, because I know that that is what clients want. They want to know that we are going to help them, educate them, but also educate their family members and help them and their fiduciaries. So with that said, I wish you a wonderful day and weekend ahead. And thank you again for taking your valuable time to spend with me about this subject, the CTA, and its challenges for clients and compliance coming up. Jeff, I'm going to turn it back to you, and I wish everyone well.
Well, thanks very much, Steve. Lots of relevant and timely and important information in there. So as we move forward here, I'll send out today's recording and the slides again. And please send your questions to Steve and me if you'd like some follow-up there. Also, stay tuned for our fall advisors forum information, which we're going to hold at the Rockville office that we just opened up. Also, very excited about that. And as for our webinars, we're going to be taking a break in July, as we always do. But we'll be back in full force very soon, and look forward to seeing you on those presentations as well. Also, again, if you're an attorney, CPA, you're brand new to the industry as an advisor, if you've been around for 30 years, again, as Steve said, we would love to meet you, learn about your practice, see how we can best serve clients and help your practice. So with that said, have a great Friday, great weekends, and we'll see you in person soon. And again, on the Elville webinar series. Take care, everybody.